Good morning. This is Professor Nathenson. This is Section 1 Civil Procedure, Fall of 2015. I'm here with my class, and we're going to do a review of Civil Procedure 1. For this section, we're going to record the video in a bunch of parts. They'll be posted separately to YouTube as soon as I possibly can post them, hopefully tomorrow. In this first part of the review, I want to talk about the format of the exam, as well as give you some guidance and hints and tips on how to maximize your time, conclude properly, and avoid things like negative issue spotting. So first, let me talk about the format of the exam. Make sure to use your time carefully. As you know from the midterm, I give points in accordance to the time allotted. I am going to do the exam in the following format. Questions 1 to 30 will be multiple choice questions. Then there's going to be a fact pattern followed by 2 essay questions. After the essays, there's going to be an additional 10 multiple choice questions that build upon the fact pattern in the essays. Okay? I highly recommend that you do the examination in that order to maximize your chances of completing the exam. So do the first 30 multiple choice, then do the essays, and then do the 10 additional multiple choice building on the essays. Don't do the last 10 multiple choice before you do the essays. It will mess with your mind, okay? Because the multiple choices that build on the essays, they add facts, they change facts. So finish your essays first. Okay, the first page of the exam is going to tell you how much time is allotted to each part of the exam. Okay, now 30 multiple choice, that is recommended 60 minutes. Then the 2 essay questions total to 100 minutes. And then the remaining multiple choice are for 20 minutes. Okay, that adds up to 3 hours. I'll give you a half hour of additional time for you to use as you wish, and recognizing that some of you will run over the allocated or suggested times. But use your time wisely. In recent years, I've tried very hard to make my essay fact patterns as short as I reasonably can. In some years in the past, they've been up to 7 pages, including a bunch of questions. This year, it's 4 pages. That includes the fact pattern, the questions, and pictures. Actually, if you just count the fact pattern and don't include the pictures, the fact pattern is closer to about 2 pages long of typed text, approximately 2 pages long. Now, in terms of preparing for the exam, keep in mind that I have a whole lot of resources available online for you to use. On the CivPro Study Resources page, old exams and reviews, practice questions, resources by subject, etc. I also have my YouTube page, and you can find lots of videos on the YouTube page. On the YouTube page, I just did some cleanup and reorganizing of it yesterday to make it easier for you to find stuff. So if you go to the YouTube page, it's at youtube.com/IraStephenNathenson. All right, or click through to it from my website. You can find videos organized by categories, such as 2015 to 16 reviews, PJ reviews, SMJ reviews, and other topics. So please make sure to do that. And you guys have been using my resources. In the past year, my webpage has been viewed over 100,000 times. That's a 3-year figure, but actually that's mostly from this past year. And as far as my YouTube goes, you've viewed hundreds of thousands of minutes, over 300,000 minutes. If somebody sat down at a computer and watched Nathenson nonstop every work day for 8 hours a day, it would take about 2.8 years to watch all the minutes you guys have been watching me. Please don't ever do that. Okay.
I have an insanity defense then.
Now the midterm, don't forget that as a study resource. In fact, in the final exam, I've used some of the midterm multiple choice questions. Maybe I just repurposed them whole, maybe I changed them around a little bit, changed the answers around a little bit. But you study the midterm, and that may help you on the final exam. And regarding your essays, keep in mind that on my website, I have extensive listings of codes that I use in marking up the essays. Things like AIC, amount in controversy, GR, give rise, COA, cause of action. So these were provided to you to help you. Now I want to spend a few minutes talking about argumentation. Okay? Now first, arguments and counter-arguments. I saw some students did very well in the midterm doing counter-arguments, but a lot of people were just looking for the right answer. But what I want from you in essays is to give objective analysis that addresses plausible arguments, reasonable arguments for both sides. Okay? Not BS arguments, but ones that are reasonable to raise. Put differently, if you play chess or football or some other sort of competitive activity, would you blind yourself to what your opponent's doing? And the answer, of course, no. You should always be thinking in advance of what your opponent is doing. That's what a good lawyer does. And you should be developing that skill and reflecting it in an exam. So what you should think about is, what is X's best argument? For example, what is the plaintiff's best argument in support of whatever? What would the defendant argue in opposition, and so on. And then choose whatever the best argument is. Now I'll talk in a moment about what are good arguments worth raising, what are bad arguments not worth raising. But lawyers are paid to solve problems. So actually what you do in your final exams, particularly the essay exams, is a reflection of what you're supposed to do as lawyers. Engaging good legal analysis, looking at both sides, and problem solving. And by the way, this stuff that I'm showing you today, I'm working on it the next day or two. I'm going to post it to the website, and I'll send you an email when that stuff is online, if you'd like me to post it. When is an issue or other matter reasonably raised? In the midterm, I said a lot of you guys negative issue spotted, right? Only discuss an issue that's reasonably raised by the facts and the law. Well, what does that mean? Well, first, it's got to fall within the call of the question, right? Call of the question is PJ, then don't be talking about SMJ. It has to address the party or the parties at issue in the call of the question. So in the midterm, the question was whether or not there was PJ over Lucy, yet a lot of people analyzed whether it was PJ over Shelley. Shelley was not within the call of the question. Next, the issue you're discussing is reasonably raised by the fact pattern in light of the call of the question, regardless of your ultimate conclusion regarding the issue. So it doesn't matter what you conclude regarding the issue, but it does have to be reasonably raised. So in a minute, I'm going to make a distinction between what's reasonably raised and what's negative issue spotting. But just to give you a hint, negative issue spotting may be when the issue itself is frivolous in light of all of the above. Now this requires you to exercise good judgment. And again, this is part of what a lawyer does. I've given you all the time you need to finish the final examination. But for you to do that successfully, you have to exercise good judgment and use your time wisely. So let's get right to avoiding negative issue spotting. Negative issue spotting, again, first discussing parties or issues outside of the call of the question. Or, this is one that people had a hard time with, discussing tangential issues, though technically falling within the call of the question, are nonetheless frivolous. I'll give you some examples of negative issue spotting. The call of the question is PJ. The student analyzes SMJ. That's clearly outside the call of the question. Wrong party. Student analyzes PJ over Sally. Student is addressing the wrong defendant. Or frivolous issue, right? Now here's something that falls within the call of the question, but is nonetheless frivolous. Suppose the defendant is a corporation, and then the student goes into a domicile analysis. Well, that's frivolous because corporations do not have domicile. They have places of incorporation and a principal place of business. Here's another one. The facts show that the contacts are single and isolated, but the student analyzes general jurisdiction anyway, even though there is 0% chance of general jurisdiction. Here's another one. Call of the question is SMJ. Here's a frivolous issue. The facts don't mention any substantive federal law at all, but the student decides to give a federal question analysis anyway. You see what I mean? Even if the call of the question is SMJ, but the facts don't indicate anything about federal substantive law, then don't go into a federal question analysis. Use that time wisely. That is a frivolous issue, should not be raised. There's another one. Call of the question is a 12v6 motion. Student decides to analyze not 8A2 regarding stating claim, but instead analyzes 8A1 and goes into an extended SMJ analysis. Don't do it. Now, remember how I said that you should look at both sides and raise arguments and counterarguments? Well, let's talk about arguments that just aren't worth raising. One is a straw man argument. A straw man argument is a fake argument, not a real man, not a real person, and not a real argument, a pretend one. They're oftentimes given as counterarguments because the student can't think of a counterargument, but knows that Nathenson likes counterarguments and decides to come up with anything, something. Well, here I want you to, again, exercise some judgment. Ask yourself when you're raising an argument or a counterargument, does it pass the smell test, also known as the straight face test, or as I like to call it, the Scalia test? You're arguing before the Supreme Court, would Justice Scalia roll his eyes or yell at you or make fun of you? If so, don't go there. Don't make non-arguments. You get no points for them. Non-argument is when an essay uses words but provides no analysis. You know, analysis is facts as applied to law, right? The it could be argued argument. It could be argued that D is subject to personal jurisdiction. The court finds that D is subject to personal jurisdiction, then D is subject to personal jurisdiction. You laugh now, but I saw some things very similar to that on the midterm. Be careful when you say it could be argued. Don't say it could be argued, just make the argument. Circular argument. Purposeful availment requires the defendant purposely avail herself to the forum state. Doesn't tell me much, does it? The court will have to decide. Because the plaintiff released her goods in the stream of commerce, the court will have to determine whether that is sufficient. Again, that's not an argument. That's just raising an issue. That's not issue, rule, analysis, conclusion. That's just issue without the rule, analysis, or conclusion, right? Other problems students get into are fight the fact arguments. Be careful. Start off by reading the call of the question. Then read the fact pattern. Then read the call of the question again and the fact pattern again. Make sure you got the facts right. Sometimes the student doesn't like the facts. So the student comes up with different facts. Now, seriously, if you believe you've sincerely found an error in a fact pattern, okay, this is very unlikely to happen, but it could happen, all right? Everybody makes mistakes. It could happen. If you really think there's an error in a fact pattern, then tell me what you think the error is and how you would resolve it, okay? But be cautious about saying that there's an error in a fact pattern. Usually when students want to do that, they just don't like the facts and they decide to change the facts or create additional facts, all right? Oftentimes students will change the facts. That might be by error, the student misreads the fact pattern. Or it might be intentional because the student doesn't want to argue the facts provided. Or for the same reason, they might add facts. So be very careful about this. Your default presumption, a very heavy presumption, should be get the facts right, argue the facts that are provided. Now finally, sub-conclusions and conclusions. Good analysis provides overall issue and overall conclusion, but also gives issue and sub-conclusion statements for each sub-issue. All right? It's a good thing to do, and make sure that your conclusions, your ultimate conclusion matches your sub-conclusion, right? Now, a problem a lot of students have is what they'll do is they'll reach a firm conclusion, right? Say, there's definitely specific jurisdiction. Yet that doesn't match their sub-conclusions. Maybe they thought purposeful availment depended on whether they used Brennan, O'Connor, or Stevens, right? Or maybe they analyzed give rise differently depending on whether it was the evidence test or the but-for test. Well, if that's the case, you can't give a firm conclusion, but that's okay. Again, use good judgment. Make your conclusions match your analysis and sub-conclusion. So a firm conclusion is okay if the analysis supports it. There is specific jurisdiction. Or you could conclude in the alternative. Depending on blah, 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 it'll go this way or that way. That's fine too, as long as your analysis supports it. Sometimes a tentative conclusion is okay, because you think it's probably going to be going one way versus another. Here's what you think it's going to be, but you're not 100% sure. Again, as long as your analysis supports it. Be careful about making equivocal or non-committal conclusions. Okay, you don't commit one way or another. That tends to be a weak conclusion. That tends to suggest the student really hasn't thought things through and analyzed it. If you think your conclusion is equivocal, explain why. In my opinion, usually when you think the conclusion is going to be equivocal, what you really need to do is conclude in the alternative. It's just going to depend on how the court resolves one sub-issue or another. All right, I'm going to stop the camera, then we're going to move into some substantive topics. We'll be right back.